Lanark County Community Justice provides services on the customary traditional lands of the Algonquin, Omamawinine peoples. We acknowledge the injustices of the past and those that continue today. As we seek to achieve reconciliation, we are committed to speaking truth and working towards justice and solidarity with Indigenous peoples. So what brought us here today? Today, we'd like to explore with our justice partners, many of who are here today, and the greater community, opportunities for a collaborative, restorative justice response to sexualized violence. We at LCCJ believe that victims of sexual assault of all ages should have the same rights as other victims of crime. They have a right to restorative justice to deal with the sexualized harm they have experienced. The voice of the victim is seriously lacking in the traditional justice system, and the experience of victims, mostly who are women, have expressed about feelings of powerlessness and alienation from the process are quite predominant. However, we also believe that these types of cases require additional considerations, preparation, training, and understanding in order to proceed through the restorative justice process. LCCJ, with you today, and our panelists would like to explore a collaborative, measured, safe, specialized restorative justice response to sexualized harm. With appropriately trained volunteers and paid facilitators, this panel discussion is opening the discussion about what needs to be further explored and discussed on the local and on the national level. The panel discussion will begin to attempt at exploring successes and the challenges, the supports and services, the training, the screening tools, and best practices that need to be in place to deliver restorative justice in cases of sexualized violence and to deliver the best outcomes. A restorative justice response to sexualized harm continues to be controversial proposition amongst many justice partners and victim service providers. Accordingly, we hope to engage the community in collaboratively contributing to the dialogue to better understand how we can best serve victims of sexualized violence with restorative justice services. We'd highly encourage you to go to our website, which also is posted in the chat. So go to our website. There's so much information there on restorative justice and restorative practices. And if you want more, we'll be happy to give it to you. So restorative justice is a philosophy and an approach that views, and this is for the 5% who really don't know very much about restorative justice, that views crime and conflict principally as harm done to people and relationships. Restorative justice is victim-centered. It's non-adversarial, non-retributive approach to justice that emphasizes the healing of victims, meaningful accountability to offenders, and involvement of citizens in creating healthier, safety communities. Restorative justice may take place at all stages of the criminal justice system, pre-charge, post-charge, before sentencing, when incarcerated, after release. And it's a community response to crime and wrongdoing. We're just going to talk about some definitions. There isn't a hard and true definition of sexual violence. We often use this term. This term is far broader than sexual assault. It includes acts that are not codified in criminal law, but are harmful and traumatic. Sexual violence include false promises, insistent pressure, abusive comments, or reputational threats to coerce sex acts. Sexual assault is any type of unwanted sexual act done by one person to another that violates sexual integrity of the person, and that is done to and involves a range of behaviors from any unwanted touching to penetration. Sexual harassment is a form of sexual violence prohibited by the Ontario Human Rights Code. Sexual violence, sexual assault are most often perpetrated by someone a survivor knows, and this includes intimate partner relationships. Intimate partner sexual violence can occur in all types of intimate partner relationships, regardless of gender or sexual orientation. The panel also wants to recognize that men are also the victims of sexual violence, sexual assault, or intimate partner violence, sexual intimate partner violence. We may refer to victims as female or the offenders as male in our discussion to simplify the conversation, and because women are predominantly the victims in these cases. And we recognize that many offenders also are survivors of sexual violence trauma. We'll also use we use different terminology. So victim, survivor, person who was harmed, complainant. We might use the terminology accused, offender, person who caused the harm, perpetrator, convicted person. It depends where we're coming from in our work. We'd also like to thank the Department of Justice for the funding to deliver this panel in honor of Victims and Survivors of Crime Week 2021. And we want to be clear that the opinions expressed in this panel are those of the panelists and not necessarily the opinions of the Department of Justice. And so now I'm going to introduce our panelists. Amber Montgomery can give a wave. Amber. There she is. She works as a senior caseworker at the Ottawa Collaborative Justice Program at Restorative Justice Ottawa. And Mark McDonald, want to give a wave? There's Mark. He's a barrister at McDonald's Law Office in Smith Falls. And Sherry Halliday, my coworker, Sherry, hi, is the program coordinator at Lanark County Community Justice. Alan Edwards, give a wave, from Correctional Service of Canada, Restorative Opportunities Program. And Maureen McLeod-Fraser is the program coordinator of the Lanark County Sexual Assault Domestic Violence Program at the Perth and Smith Falls District Hospital. Yeah, so here we go. We're starting our panel discussion. First question to our panelists, and I'm going to start with you, Mark. Many people victimized by sexual assault or violence recognize the need for a robust, safe, and respectful alternatives to the criminal legal system. How can the addition of a restorative justice option help survivors improve their opportunities to experience the kind of justice they want and need? What happens in a sexual assault, sexual violence case that goes through the criminal justice system? What benefits can you identify in using restorative justice response to sexual assault, sexual violence? And why do you think this should happen or not happen? What is it that is not working? What do we want to address here? Mark?
Thank you, Joelle. And there's a lot of questions in there. I think it's important to start off with, we have to look at our current justice system, our criminal justice system, and recognize its limitations. First thing I'd point out is that it's an adversarial system. There are winners and losers. A trial assumes that truth can be achieved through a class of equally matched adversaries, and the victim can feel like a pawn in this game. The next factor I'd ask to consider would be that it's inherently stressful for all parties. Courts can be intimidating. There are rigid rules regarding communication, when you're allowed to talk, who talks, how you talk, and even what you can say and what you can't say. The courtrooms are open to the public. There can be a number of strangers in a room. There can be the press. There can be supporters of the accused. There can be just curious people who are members of the public. And especially in sexual assault cases, the victim is sharing some of the most intimate details of their life and maybe some of the most traumatic experiences of their life in an open courtroom full of strangers. The criminal justice system that we have now doesn't search for the truth. There is no healing. The test is, has the Crown proven their case beyond a reasonable doubt? And finally, I would suggest that outside of youth sentencing, the focus with respect to criminal justice cases is denunciation and deterrence. That's in the Crown Policy Manual. That would be, that's been said by our Supreme Court many times. Restorative justice, on the other hand, focuses on healing and making amends. So I would say that we have a system right now that doesn't recognize the needs of sexual assault victims. And in many cases, it can do as much harm as good or more harm than good.
Alan. Thanks, Joellen. Yeah, I think I'll follow up with Mark's comments. You know, I think restorative justice sort of represents a challenge to what we mean by the word justice. Who gets to define what justice is? And I think part of where I'm coming from is that survivors play a fundamental role in defining what justice would be for them, what justice needs they have after they have been assaulted. And you know, I don't think it's any sort of great secret or surprise that the criminal legal system is not handling survivors' justice needs in ways that are enduringly satisfying in any meaningful way. And that could account for the fact that only 5%, according to Statistics Canada, only 5% roughly of survivors of sexualized violence have anything to do with the criminal legal system at all. And so that leaves 95% of survivors with no justice process. And in restorative justice, you know, we certainly recognize that survivors don't all have the same needs for justice as each other. Sometimes survivors might want a kind of validation and vindication that go with the perpetrator being found guilty in a court of law. Fair enough, I certainly respect that. Certainly a lot of other survivors I work with in the Restorative Opportunities Program, you know, they're looking for validation, vindication. Getting answers to questions is hugely important to many survivors. Having safe, facilitated dialogue in advance of an offender returning to the community, for example, those kinds of things. Having the person who has caused harm speak meaningfully about their accountability and what they're hearing from the survivor. In all of those kinds of situations, restorative justice, I think, may have something meaningful to offer. You know, I think when you look at some of the research that's available, and there unfortunately is not a lot of research out there about restorative justice working or not working in sexualized violence cases. And mostly that's due to things like the moratorium that we have in Canada that was created by the gender-based violence movement in collaboration with the criminal legal system to bar the door from survivors accessing restorative justice as an option in sexualized violence and intimate partner violence cases. And so when you have a moratorium, then there's not a lot of work that can go on. And when not a lot of restorative justice work goes on, there isn't a lot of research that's accumulated that we can report on. So it's kind of a catch-22. But certainly with the survivors I've worked with, being able to explain the impact of their actions directly to the person who's harmed them, get crucial answers to crucial questions, not just any old questions that keep people up at night, questions that keep survivors from being able to take the next step in their life. And there's usually only one person or a very, very small number of people who can answer those questions. And for better or worse, one of them is the person who caused the harm. And I think we need to recognize that the criminal legal system is massively failing survivors. And after 20 years of a moratorium on the use of restorative justice, I think we need to start a fresh conversation about what survivors are needing out of the justice response and how we might be able to address those needs as best we can.
Thank you, Alan. Yeah, I think key point you made there is about, how does the victim want justice? What are they looking for in terms of justice? Does it always need to be the legal system? And if it is the legal system, then by all means, that's where they need to be. But if it isn't, can we not offer them something different? I'm going to go to Amber now at Collaborative Justice.
Awesome. Thanks, Joellen. I think there's a lot of questions that you posed there, and they're not easily answerable questions. So I want to try to go through them a few at a time. So in our experience, generally what happens at the criminal justice system following charges being laid, and I acknowledge what Alan said is that this is a small number of cases compared to what's out there. But really, there are two choices once charges have been laid. The first is that the offender accepts responsibility and will be sentenced. But there's issues with that. There's problems that the consequences for offenders pleading guilty will often deter offenders from taking legal responsibility, not necessarily because they don't believe that they've done something wrong, but because the effect of having a conviction of a sexual assault can be life-altering for the people that do it. So being on a sex offender registry can severely limit people's opportunities in their futures. But there is the option to accept legal responsibility. So if they go that direction, if they do not accept responsibility, let me be clear, what follows is a trial. The trials undoubtedly re-traumatize victims, their communities. They force polarization between the parties. It pits them against each other, like Mark said, in a battle of who appears to be the most credible. There's no room for emotion. There's no humanizing of the parties. If anything, they can't be anything less than perfect in their testimonies. There's no room for empathy for the victim, etc. Like there's so many things wrong with the way the system we have that works. We've heard from our participants that it's often the trial that was the most damaging, the most traumatizing, challenging, and difficult experience to go through that caused even more negative and long-term impacts on the participants' lives. So for the victim, in the course of that experience, for them to relive what happened, detail by detail, to be questioned on how and why it happened and what part they played in that, to be made to feel shameful, embarrassed, violated, vulnerable, whatever they felt, in such a public setting and in such a personal way, it can be really damaging. On top of that, there's worry, how do they heal from this, right? How will this affect their future relationships, their future lives? And so the only way that the criminal justice system that we have can show a victim that they've taken the incident seriously is through the sentence. And sentences are limited, we know this. The only measure that we have of validating the severity of the offender's punishment is the length of the jail sentence, right? So whether or not that has value to the victim, it's debatable. What are we left with, right? So we've gone through the system. This is what we have. This is what exists. What options for healing do we have for people that have been through sexual assaults and sexualized violence, right? And this is at the core exactly what caused us to start advocating and start developing RJ processes. So in appropriate cases, RJ processes can offer participants the opportunity to speak from the heart, to tell their experiences of the event, to have a voice, to be heard, to be respected, to say what you need to say, and know that each party is there willingly and choosing to listen. The benefits of RJ processes can apply to both victims and offenders, but in addition, they allow the opportunity for the offender to be meaningfully accountable for their actions, which from our experience with our participants, this can be the most important thing. The RJ process, as we see it, is based on the belief that those affected by sexualized crimes are capable of identifying their own needs and acting collaboratively to address them when they are included, treated with respect, provided with information, support, and the tools to do so. So for victims, the RJ process can provide an opportunity to learn more about the offender, the accused, to access community resources to assist in their recovery, to receive an apology, to describe the impact of the crime on their life, to assess whether the accused is remorseful, which can be very important, to have a voice in the criminal process, and to indicate what is needed for meaningful reparation and to receive reassurance about future offending. The underlying hope I think that we have when we work in RJ is that the processes can lead to healing, to closure for everybody, but particularly for the victim.
Mhm. I had never heard it said that way before, Amber, about, once the charges are laid, they can, be accountable by pleading guilty, but they're often encouraged not to because of the consequences. So, they
What are the
fight the
options?
charges, they try and get off, whereas they're, at the heart and root ready to be held accountable in a way. Maureen?
So I just wanted to add to the point about, when they decide to take accountability, that there also are victims that are not represented, as sometimes in the court justice system, the court will say, well, we'll take these two because we know we can get a better case, or the accused is going to plead to 2 instead of the 10 or how many more. So those victims are not represented in the justice system at all. And so restorative justice could be a place that all victims are have a place if they choose.
Mm-hmm. Anyone else on the panel want to contribute to this question further?
I just want to mention, we also take youth cases. So a lot of times this is the best opportunity for them to be educated about consent. Like Joanne said, there's very different levels of sexual assault and sexual violence, like inappropriate touching, things like that. Do they need to go through a court process, or is that something that we can have a conversation and get them the right supports and services so that they actually learn what they're doing moving forward?
Mm-hmm. Maureen?
I just want to say I have an example of that recently where the victim I was working with said, I really don't think he understands what he did was wrong. And that is exactly your point. I think that's where I see restorative justice as such a huge benefit, is to catch people early where we are helping them to understand.
Mm-hmm. Yeah, we've seen that in our work too, getting especially the really young teens who are just starting relationships and, do not understand consent and, make some pretty poor choices and just need a greater understanding of what's okay, what's not okay. Any more input? Mark, want to say something?
Yeah, sort of to build on that with respect to youth cases and consent, it almost feels sometimes like our current system, we almost armchair quarterback. We look at what happened in a specific instance that may have taken mere seconds. And a lot of these issues of consent are difficult for lawyers and for judges to wrap their head around. Is that consent? Is that not consent? And the regular criminal justice system can fail with respect to that, because ultimately the goal should be to have more people learn about consent and respect consent, as opposed to just punishing people.
Mm-hmm. Mm-hmm. Okay, I think I'm ready to move on to the next question, everybody. So at what point in the criminal justice system can a restorative justice response to sexual assault, sexualized violence happen? What are the different entry points in the restorative justice process? And key to this is who should be allowed to initiate a restorative justice process. And I'm just going to go through kind of in a logical order. Maureen from the Sexual Assault Domestic Violence Program.
So, we're a client-centered organization. And so we believe that the client should get to make the choices that they have. as Alan said, many people do not report, and that's why. And we have lots of people who come to us that don't want police involved. So there's lots of really good reasons for this to be an option at a point where the survivor is given the options, and with some counseling to understand what's going to be the best healing for them. I would like to see an entry point into RJ that doesn't include the police. I don't know what that looks like, but I think with the number of people that I have that don't want police involved, that it would be nice if there wasn't, the criminal justice system at all, and that you could enter with the appropriate supports on both sides and still with the same processes, with everybody volunteering and all of the stuff that RJ has in place. I see that as a point. I also, if there was, in my example where sometimes there's a plea deal and some victims are not represented, I would like there to be an opportunity for some restorative justice to happen for those clients as well. If there was an entry point even after conviction, whether that could still happen for some victims.
Thanks, Maureen. Amber, I think you can provide some input about that.
Yeah, I definitely, I mean, I can speak to exactly where we're situated, and maybe it's helpful if I can sort of spell that out for people so they know exactly sort of where we function. So the Collaborative Justice Program, we operate in Ottawa, out of the Ottawa Courthouse. We can accept referrals for adult and youth cases, and they come to us through Crown and Defense. So our model was really created for us to run in parallel with the criminal justice system. So it means that our process takes place post-charge, so after someone is facing charges, but prior to them being sentenced through the criminal justice system. So it's a bit of a sweet spot after they've accepted responsibility and before they're going through for sentencing. So they are in the system, they are going through, there is a formalized complaint that's been laid and charges that have followed. So that comprises the bulk of our casework. But with that said, we also accept pre-charge and diversion youth cases from a community-based diversion program here. With any of the cases that we get, our process remains exactly the same. We do the same work in the same order with the same sort of priorities and values behind it. So with that said, I should say that we don't accept domestic violence cases. So for the most part, the types of cases that we take that are referred to us are really different sexual assaults that have varying severity and sort of natures to them. So that's really sort of where we function. I think through our casework in these types of cases, successful participation through the process helps the parties create what we call a resolution agreement. And I know I'm jumping the gun, but in a further question, we'll break down exactly what we do and how we do it. But the reason I want to talk about the resolution agreement is because this is the culmination of our process, and it's the only information from us that goes to the referral sources back to court. All the other information that happens over the course of our process is maintained as confidential. And this is really important for us in our work in that we have to create a safe space for the parties to be open. We have to be a place where they can be open, they can be honest, they can be vulnerable with each other, they can talk about how the incident has affected them. And they can't do that if they feel that everything that they say is going to be used against them. So our process is also what we call without prejudice. We're very clear with the participation that neither we nor they have control over the sentencing outcome. That remains the role and the responsibility of the judge based on where and when we engage with the parties. But with the resolution agreement, our experience is that the judges really do like to receive the resolution agreements. It helps them to know what the victim has asked for, what the offender has done to make amends, what consequences the offender has already faced. And they do review them quite carefully. They refer to them in court and often are part of sentences that come out of the court. So the agreements that we have is that the judiciary will take it into consideration. Whatever comes out of our process is taken into consideration at the point of sentencing. And so that's important to know, that it's not just behind the scenes, closed doors, things that are happening. These are formal processes where the parties develop the resolution together, and then that gets submitted to the court at sentencing. So our work is really to prepare the parties for all of the ranges that might come out of court and to ensure that the participants are engaging in the processes with their informed consent, knowing the range of outcomes. So no surprises. Nobody is getting shocked at the end of the process. They're not being used and then all of a sudden the sentence is lighter. They know the range of outcomes that's possible from the very beginning. So they know what potentially could be coming. It's here or here. It's anything between this and this, right? Our work with the parties is also important in that the process is often, because we are connected to the system, it's often initiated with the offender. Because of our connection in the system, most of our cases are initiated through the offender, but it is possible for us to accept victim-initiated cases as well. So should a victim come to us and learn about our services, reach out to us, ask for anything, we would do our best to offer them an exploration, right? We would explore whether the case is within our capacity. We would explore whether it's appropriate. And we would prepare the victim for the possibility that if the offender is not taking responsibility, the case may not be conducive for a restorative process as a result. So again, there are certain elements in our process that need to be in place for the case to move forward. And it doesn't mean that we can take everything and move forward with it because of where we're situated. So I hope that was a little complicated, but I'm hoping that made sense to sort of situate where we are and sort of how we function in conjunction with the criminal justice system.
Thanks, Amber. Yeah, that was a really good explanation of how you work alongside the traditional criminal justice process. Sherry, I'm just going to back it up to Sherry. I probably should have asked her first, but if you could talk a little bit about Lanark County Community Justice and the work we do.
Yeah, so I take pre-charge youth and post-charge youth, and same for adults. And yeah, what Maureen was saying, if this could be an entry point. I'm not sure how that would look, Maureen, because a lot of our cases, they're motivated to get their charges dropped. So that's why they participate in our program. Like, this is true, like not every person is wanting to participate in a restorative justice process, and that's fine. But it is more or less victim driven. I always call the victim first and have conversations, talk about the process, ensure that they know it's a safe spot. Sometimes that takes a number of conversations. And it's been hard with COVID because people aren't comfortable over Zoom. It's hard to have those conversations over a conference call on Zoom platform, especially when I'm dealing with young offenders, male young offenders. So a lot of kind of tailoring needs to be done for certain kinds of cases. And in the restorative justice process, we can do that, right? We can get creative. You can't do that in the court of law. So yeah, that's our entry point. We also come up with an action agreement. It's also a very confidential process, the same as Amber said. And then my job is to monitor that, and I report back to my referring source. We also have a huge volunteer base that work very hard in our community to make these forums happen. Without them, we could not do the work that we do. And so I really appreciate that. And I know a lot of our facilitators are very faithful, and they've seen the work and they know the magic that restorative practice can do.
I'm going to give it over to Mark and then Alan.
I think the question asks who should be allowed to initiate the process. And in my view, anybody should be allowed to initiate the process. I think when you're asking why would the accused want to initiate the process, well, there's the obvious benefit if it's pre-charge or pre-sentencing, that there would be a benefit to the accused if the charges are dropped or sentences reduced. But there could be other reasons why an accused would want to initiate the process. The first could be that the accused could feel that they've done something wrong, but it doesn't meet the level of criminal liability. So that there's an issue there, but is it what they did illegal? Is it not illegal? The second one is they may actually not know what they did is criminal. I had a youth client one time who was, I had a father come to try to bail him out. And the father, when I reviewed the allegations with him, the father said, why is he being charged? All he did was get to second base. And you realize that this youth probably had inappropriate upbringing with respect to what is consent and what is sexual assault. So for that youth, certainly as a defense counsel, that youth you would be able to see would benefit greatly from such a program. Another reason is, and this is for both the benefit of the accused and as well of the victim, is that a lot of people still have existing relationships that need to be maintained. And you can think of, for example, two ex-spouses who may still have to parent together. What happens if that spouse is sentenced to jail and child support stops? So there may be, somebody may want justice, but they may not want to see justice look like what the traditional justice system does. These relationships could still be parent-child relationships, aunts, uncles, people that are still going to have family relationships. Moving on sort of with respect to the question, I think the other thing we have to ask is who is the victim? And I think a victim can be very broad, and it can be any number of people. It could be the mother of a child who's sexually assaulted. And finally, I think with respect to who should initiate it, it obviously must be voluntary. The accused, everybody must agree.
Mm-hmm. Really good points there, Mark. Alan, you want to contribute to it? It's really interesting.
Yeah, thanks very much. Yeah, I guess the entry point that I would want to sort of shine a light on here has to do with the work that I do in the Restorative Opportunities Program, where we are working with on a post-conviction basis with regards to the offender. And these are crimes for which the offender has been sentenced to serve 2 years or more, which means that they are federally incarcerated. So the trial has come and gone, or there's been no trial. The offender pleaded guilty or was found guilty, and now they're doing time. And after that, which, as you know, is after some number of years, usually after a sexual offense, that's when a survivor might come forward and request our services. We're a national program, and so there are about 25 of us facilitators spread out across the country. We're one of the only national restorative justice programs in the world, and we've been around for about 17 years. And so at this point in our history, we have facilitated a number of encounters between survivors and those who have offended sexually against them. And I think it's important to note that when an offender participates in this program, it has no effect whatsoever on their sentence, on their parole. It's not written up in any report that goes to anybody, and it doesn't come up at all. So the assumption is that an offender participates because for them it's the right thing to do, not because they'll get a nicer pillow or anything else, and so we have a sort of like a no carrots, no sticks approach here, and for offenders, and they participate when it's ethically the right thing for them to do. And in the sexualized violence cases I've worked on, I would say just over half the time it's initiated by survivors, and the other portion is initiated by offenders who have some kind of institutional support to kickstart the case. And we work with folks for between about, I don't know, say 4 months to 2 years, maybe longer. The very, very longest I've worked with anybody was actually in a sexualized violence case, and that was 9 years, waiting for the right time for the offender, because the victim was already a long time ago. And so it's definitely worked for the patient. Yeah, so again, either participant can initiate. I so appreciate Mark's comment that we need to have a very broad definition of victim here, a very inclusive one, so that parents or the children of or whoever can initiate, can be part of this as a victim, someone who is impacted negatively by a crime. In addition to the sexualized violence cases, we also work with a lot of cases. Most of our cases involve the loss of life somehow, whether it's through manslaughter, murder, drunk driving causing death, those kinds of things. A lot of sexualized violence cases, a lot of domestic violence cases. And we never, ever, ever want to assume that survivors necessarily want to sit down in the same room with the person who's harmed them. So we offer as broad a menu of communication options as we can think of. And so a survivor can obtain information from the offender through us, the facilitators, if they wish, or maybe an exchange of letters or an exchange of video, us asking the person who's sexually offended questions that the survivor has asked us to ask them, and we videotape their response, and then we take the tape back and watch that with the survivor. They can have video conferencing with in separate cities, towns, provinces. They can have a surrogate offender, a surrogate survivor, and any of those, all of those, and as well as face-to-face dialogue. And so the entry point then is post conviction, incarceration, or afterwards. Thanks.
Great, Ellen. So you just touched on it a lot about the case preparation a little bit. There, I'm wondering if you could talk about what does case preparation look like, or should it look like, in sexual assault, sexual violence cases, and how can we determine what needs to be taken into consideration when deciding to proceed with restorative justice, and what do you think needs to be addressed as the participant proceeds with the development of the case?
Well, I hope everybody can sort of pour a tall, cool one and sit back, because we'll be a while answering this question. It's a very detailed one, and it's something I feel very passionately about, because certainly in my experience of doing this kind of work with survivors and offenders, I would say that the preparation stage accounts for, in my estimate, about 95% of what will make the dialogue go well or go poorly. The quality of that preparation is so vitally important.
I just want to comment that I'm looking across the group and, all the practitioners, and there's a lot of nodding heads there about the importance of case preparation. Like, it's just so key to our work. Go ahead. Sorry, Alan, for interrupting.
Right. No, that's fine. And it's interesting, because I think when a lot of people think about restorative justice encounters, they think of, that their thinking starts when everybody piles in the room to actually have the dialogue. And really, that's the end point of months or years of preparing people to be ready for that moment. And so when I think about preparation, then, the first look of it, I guess, is that it's extensive and lengthy and needs to be that. There are some very exceptional circumstances where maybe somebody or two or more people they come and they don't need that amount of preparation. They're almost ready to go when they first meet us. Fair enough. I don't meet many of those people, but that's a possibility. But certainly, when we talk about working with people for 4 months to 2 years or more, it's meeting with them once every few weeks to discuss, between me and the survivor or me and the offender. There's homework for people to do, things to reflect on, potential directions for them to ponder. And the fact is that a survivor's participation in restorative justice has to fit in with the rest of their life. And, the rest of their life has its own sets of demands on time and attention. But I think that really, for me, the key elements of preparation in my view anyway, are first and foremost relationship building, establishing a relationship of trust, where there's clear respect for the survivor's self-determination, her voice, her choice, her justice needs. My part in that is to be a trustworthy companion on that journey, not a guide and not an expert. Restorative justice absolutely rejects the expert paradigm, I would say. But I want to be somebody who's committed to working to reduce the survivor's suffering, and that I'm there to be humble and knowledgeable. I want to have an ongoing exploration of what the survivor is looking for and needing through communication with the person who harmed her, how to enhance the likelihood of meeting those needs, and also having ongoing reality testing, an honest and ongoing conversation with her about her safety, her wellness, her needs for support if she has such a need and from whom. Related to that is discussions with her therapeutic support person or support people, making sure that her therapeutic goals are not conflicting with her justice goals. We don't want to get in the way of other things that she's trying to accomplish. Discussions with her other support people to gauge the extent to which the kind of support she wants is what they're willing and able to offer. Sometimes, given that, as Mark was mentioning earlier, the survivor more often than not knows the offender. They're in the same community, maybe in the same family, maybe they go to the same church or whatever it is. And so that can create a lot of, as you know, polarization, and people who are sort of for the offender or for the victim and against the offender and all this kind of stuff. And there are times when we sort of jump into that fray and try to assist people to sort of be more genuinely, generally supportive of them both, and cut the polarization, because that's certainly hard on survivors and offenders alike. And then in the final meeting before the dialogue, then inviting her to make decisions about who will arrive for the dialogue first, who sits where, what the setup of the room is like. Does she want to be able to exit the room without having to pass in front of the offender? Is there a table in the room? Is there no table? Do they touch at all when they first greet each other, a handshake or something? Who speaks first and about what? How can I best support her? And also similar conversations with the offender. How can I best support him? And so on. And I reaffirm what I see has always been the case in these situations, is that she'll know when she's done. She doesn't have to look at me. She doesn't have to wonder. She'll know when she's done. And so that's in as brief a nutshell as I can figure out how to do it. Some of my thoughts anyways on the crucial importance of preparation and what some of that preparation is.
Yeah, case preparation is just so important in these cases, as we've just said. And, you know, I have the privilege of working with Sherry, and she seems to know, having done this for so long, when to just like set the case aside for a bit. No, this one needs to percolate. It's not ready to go yet. They need a little bit more information, more conversation, just to put it away for a minute until it's in the right spot to take the next step forward, whatever that next step is. So I'm going to turn it to Sherry right now.
Yes, preparation is everything. Absolutely everything. There's no way you can put two people together without any kind of preparation. Like, that's just unheard of in restorative practices. And a good facilitator will, everything will almost be in place before you get to the conversation. Like, it's not a big surprise, like Amber was talking about. Like, nothing's going to hit you at the end of this. Like, what you're up to, what response you want to give. You have your opportunity to speak. The other party has an opportunity to speak. There's a question period, and everybody knows in advance who's going to be there, what time they arrive, who walks in the door first, who's going to sit where. All those things are really important little points that in having a successful forum or conference or meeting, those are things that the facilitators have to really, really take knowledge of. And a good facilitator will have all those little T's crossed and the I's dotted. Yeah, preparation is it.
Amber, I'm going to turn the question over to you and just give you a little reminder. We're talking about preparation, but also about how we can determine what needs to be taken into consideration with the restorative justice process. And what do you think needs to be addressed as they proceed through the development, specifically to sexual assault cases?
I know there's a lot of practitioners around the table. I know there's a lot of RJ folks on the call, but I guess I want to take it a step back and really sort of what you were both, but just to break down our CJP process and some of the points along the way, if that's okay with everyone, just to slow it down. Because I think for us, the most important thing for us to say about our process is that restorative justice process, especially in cases of sexual assault, do not need to be meeting based, like Alan said. There's a lot that can happen through the process, through communication, that never ends in a circle. And you have to come into these cases without any expectations of knowing what direction they're going to go or what needs are going to come up. And so for us, that process is the process, right? It's not a process leading to something. It's not in betweens to get to a certain point. There is no end goal for us. The end goal is, like you said, she's going to know when she's had enough. She's going to know when her needs have been met. And so the process is very, very flexible. And I think I can't say that enough. Restorative justice is based on the needs of the parties. And so it takes whatever direction the parties want to take. And so for us, you know, as a core sort of understanding, the first thing that we do in our process is we meet with the offender. And there's reasons behind us doing that. And I guess I want to sort of talk to that too. We start with the offender to make sure that they're appropriate. There are lots of people that might be able to take responsibility, but aren't remorseful. And those are not appropriate participants in an RJ process. So talking through with the offender, making sure that they meet the criteria of accepting responsibility, the fact that they're remorseful, they're choosing to make amends to the victim, and they're choosing to want to do this, right? That they're choosing to participate in a voluntary process. Those steps cannot be overlooked. They are the core of restorative justice practices. And if they are skipped, the process will not go well. They have to be at the core of whatever you do. And so the reason behind us doing that with the offender first is often that we want to lower the risk of the offender re-traumatizing the victim and failing the victim a second time, right? In any way, shape, or form. We want to make sure that we're doing whatever we can to make sure that we're setting it up for possibilities down the road. So in that first meeting with the offender, we're explaining all of those things, we're canvassing them, and there are offenders that don't pass the intake, right? It doesn't mean that you go forward just because you receive a referral. There are safeguards in place. If they can't convince me that they're remorseful, there's no way that we're moving forward with that process, right? So really at the core of it, if he meets the participation criteria, if he wishes to participate, then we would reach out to the victim. And at the very least, we provide them with information and support about what's going on, right? For a lot of victims, this may be the first time that they've been contacted. We don't know what supports they've received up to this point, if any. We need to be that voice of reason. We need to be that voice of support. We need to give them as much information as possible because information is empowering. The more information you can give the victim at every point of entry is important, right? And so that sometimes is all that you do. They may choose not to participate, but the sheer call to them to say, we care about you, we validate your experience, and we want you to know that the offender is taking responsibility, right? Sometimes that might be as far as you go. But really the question that we're asking the victim is, do you want to have communication with the offender with us in the middle? Again, we're not calling people up to say, would you like to meet the person that held you up at knife point and then assaulted you? you can't do that, right? It's not safe. It's not appropriate. You have to take it in baby steps, right? And so that's not to belittle the victim. It's to say you're meeting them where they're at, right? Wherever they're at. And if right now they just want information about what's going on, they want to know what charges the person is facing, they want to know what potential outcomes could happen, well, then maybe that's your first step, and maybe you leave it at that for a little while. So it's really important to give that information first and foremost. And sometimes it's not a yes or no answer that you're asking them. Do you want to participate? Yes or no? Would you like information about what's going on, right? You have to really, really sort of do it slowly. So I think if they're interested in communication, what does that communication look like, right? Knowing that you're in the middle, there's some distance, there's some safety. If they're interested, then we begin those discussions. We begin to exchange information, and we start talking about how they've been affected, and we give them a safe place to talk about those things. If they're not interested in participating with the offender through the process, we close our file. We advise the court, the case continues through the court system. It does not affect that process. We run parallel to the system. So it's important for the victim to know that they can do this or not. This is not a forceful thing. There's no pressure in any way, right? We're still going to give them information. We're still going to give them support. We're not going to cut them off if they say no, thank you. We're going to still do what we can to help them, but we just know that this isn't a process that will be helpful for them right now, and that's fine. We know that all victims are unique, right? The needs that they identify from our experience are often combination or variations of the need, like I said, for information about the crime, about the accused, or about the system. They need the harm to be taken seriously. They need for accountability. They need an apology often, right? They need the offender to understand the impact of the crime. And often it's practical or symbolic reparation. And what does that look like? I'm not coming in and telling them, do you want this, this, or this? I'm saying, what would be helpful for you? What does that look like for you? How does that play out in your life, right? What would be most meaningful? And I think when we talk about meaningful consequences, that's what I mean. It's not impositions. It's not dictated, do you want A, B, or C? It's how can we help? What does that look like, right? And so sometimes the victims will look at us and say, well, nobody's ever asked me that, right? I've never thought about what might help me, right? Okay, well, let's think about it, and let's give you the time to think about it, right? I think you cannot rush these processes. They take the time that they take, right? And you really need to give people the time to process some of those questions that may be quite difficult for them to know the answer to. So like Alan said, a lot of our work is back and forth, right? And because we live in that case development phase, and maybe that is the process, is that process, it's a series of conversations back and forth and back and forth. And like Alan said, communication can happen in all sorts of different ways. So whether it's through me, whether it's through writing, whether it's through videos, whatever that looks like, we're going to facilitate that. And maybe one letter answers one question and opens the door to another set of questions, right? It's not to say that once they've asked a bunch of questions, we're done. It's simply to say it opens the door to other needs that might come up. And sometimes practical assistance, right? Sometimes those are really, really meaningful. What would help them in that moment? How do they get to that next step, right? The dialogue, like I said, it can evolve to a face-to-face meeting. And I think you guys have both talked to some of that case preparation that's involved, so I won't go into that. But in our process, whether a circle is held or not, it's likely that the parties will develop a resolution agreement. And that basically is a culmination of the process, right? It's something that is not a report that's written about them. It is a report that they write. So they tell the court what's been meaningful to them. They agree on what elements they want the court to know about the process. And so for some cases, that can be very, very detailed. And for some cases, it might be 3 points saying we exchanged information, we received an apology, we feel the case is resolved, right? It really depends on the parties and what they want the court to know about what's been meaningful to them. But it's also a place for us to share about what the offender has done to be accountable. What do those resolution points look like? What does that reparation, what form did that take, right? And for the court, it's for them to know what's been meaningful to the victim, right? What has already happened? What has he already done to prove himself, right? And I think some of those things are important for the court to know. as they look at potentially what could happen next, right? Again, we don't promise the offender that this is going to impact the sentence. The victim knows that whatever happens, they don't have control over what happens next, but this is a place for them to have at least input into what has been meaningful, what has happened up to this point, and what do they want the court to know. So I think for us, like I said, that process is complicated, it is layered, it is different for every party, and yet that's the point, right? These are unique parties, these are unique cases, they cannot be cookie cutter approaches. It wouldn't work. So we are here at their disposal to work them through a difficult process.
Mhm. So Amber, is there anything that I'm putting you kind of on the hot spot, and it doesn't have to be Amber that responds, but that is particular to sexual assaults, sexual violence cases that you think, I know you mentioned that, that they have the counseling or supports. Alan mentioned that, we need to ensure that it is not in conflict with their other goals or the other programs or treatments that they might be involved in. Is there anything else that you want to add to that that's particular to
But sort of making sure they're in a good headspace to do what they're doing? Is that what you mean? Or
yeah, I mean that, but I also mean, are there certain programs like sexual assault, domestic violence programs? Should the person always be accompanied by someone for victim services when going through the restorative justice process? Those sort of thoughts. Yeah.
I think our thought around that is that it really is up to the parties to make those calls, right? I mean, the assurance that they don't have to meet with the offender at every point, the motivation for them is that they get to decide what the next step is, right? I think if they want a victim service accompaniment, absolutely bring them along. They're under the same confidentiality sort of expectations that anybody would be. But I think, to be honest, in most of the cases that we've dealt with, even when we've offered the option for people to bring supports with them, they often choose not to. They often choose to do this on their own and then go home and share their stories with their significant others. And we would make sure that they have those support networks in place to go home and have those difficult conversations. We might make sure that if they're in counseling, they ensure that they have something set up the next day. I think it absolutely is part of your case development to make sure that they have a network of support around them. But to be honest, when it comes to the information sharing through the process, our experience is that most people come to those meetings on their own and deal with it in their own ways on their own.
Okay, thanks for answering that question. I put you on the spot a little bit there. Sherry, you have your hand up.
Yeah, I think that is perfect, Amber, in the perfect world, that's what it needs to look like. However, it isn't. It's not offered at every court. It's not a constant, in every province. It's different with every judge, with every crown, with every duty council. So people are not given that opportunity. And because of the moratorium, we haven't really seen any of that. So yeah, wouldn't it be great if they had that option, but they're not getting the option. And that's, I think, one of the main things we're here to talk about today. So good for nailing that.
Okay, so can restorative justice respond? And Maureen, I think you touched on this, and I think Mark, you'd be a good person to respond to this question to start. Can it respond to sexual assault and sexual violence outside of the criminal justice system, and or cases that are not pursued by the Crown, because the Crown has no reasonable prospect of conviction? So Alan talked about the 5% that even are reported. Well, what about all the other cases? Or what about the cases that will be dropped because they have no reasonable prospect of conviction and the case is not pursued? So Mark, I'm going to turn it over to you.
Yeah, so the Crown has an obligation to determine whether or not there's a reasonable prospect of conviction. And that obligation goes through every stage of the proceedings, including trial. The Crown can, in the middle of a trial, decide that there's no longer a reasonable prospect of conviction and withdraw the charges. Again, Alan pointed out, only 5% are reported, even less are charged, and even less are prosecuted. And I think one of the reasons is that sexual assault cases can be difficult to prove because there's often no other corroboration. In a robbery, there's often corroboration. In sexual assaults, especially historic sexual assaults that occurred a long time ago, there may only be two people that were involved in that sexual assault, the accused and the victim. And when we were dealing with proof beyond a reasonable doubt, that's an extremely high threshold. That's not, is it likely to have happened? That is almost certainty. It's not certainty, it's not absolute certainty, but it's very close. So in those types of cases, a restorative justice program would be excellent for both the accused as well as the complainant. And I think we have to remember a lot of accused were victims themselves. And a lot of accused are struggling with other issues. They're struggling with alcohol, they're struggling with mental health. And that is something that a restorative justice approach can look at. It can look at healing everybody, including the victim. So I absolutely think that it can work in cases where the Crown's not pursuing. And in fact, it should be an option for people.
Maureen, you touched on this earlier a little bit.
Yeah, I especially see it in my youth clients, not so much in the adult population. So, I think we're talking about it as both, but I think there are, in my line of work, I see more benefit for youth, for those, like we've talked about. These are people that are in the community. They go to school together or in the neighbor's school, or, people know each other when we're looking at a lot of these youth sexualized violence regarding the youth. And so those things I think are really important. And I don't know how many times I've heard, the court, well, we just don't have enough to proceed, or we don't have enough to investigate. That drives me crazy. Before they've even completed the investigation, they're taking one interview and saying, yeah, I don't think we're going to go further. So, I think we really have to, I would like to be able to offer this as an option for a lot of my clients, especially the youth ones. I think that's perfect. And as well, I mentioned earlier, even for those people who are convicted, I think it's something that should be offered for all victims, whether their assault was part of the charges and conviction or not. I think that's something that would go a long way to healing.
We talked about how these cases are driven, what needs to be taken into consideration. We're talking about victims in particular. Should it be victim driven, accused driven? But what does it mean as someone who works in this area to be victim focused? What does that look like? And how does it play out in your practices and your processes? And can you give a few examples of what it means to be victim focused? When we say that, what do we mean by that, Amber?
Yeah, I have a couple points I just want to touch on, and I'm sure they're probably very similar to what other people will say, but I think I touched on it last time, and I think we value the power in that initial contact that we have with the victim. Any work that you do in a sexualized violence case, we know that it has to be sensitively done. We know that there's trauma, there's hurt, there's a resulting sense of loss of control. So the willingness of the victim to be open to participation may well be determined by the way people interact with them in that first outreach, right? And so we really feel that outreach is important. It needs to be done well. It needs to be done with the right information. Again, you can't just have a police officer calling a victim saying, hey, do you want to meet the guy? Because it's not a representation of what restorative justice can offer the victim, right? And I would hate, and it has happened to us in the past, where doors have been closed firmly because that outreach has been done badly and it's been done with misinformation, right? We know from experience that people don't know what we do. They don't understand it. It's complicated, it's layered. And so we would really like to be the ones to be able to explain that in a way that's holistic and true to the victims, in a way that they really get a chance to make that decision themselves if this is something that they're interested in. It's not for everyone. It's an option, right? And I think that's where we come in. It has to be an option, and we want it to be an option for as many people as possible. And the more doors that get closed because of misinformation, it's another victim that doesn't get the service, right? So that first contact with the victim, it's a very important step. Like I said, it might be the first outreach that they've received. It's important that they be reassured of our impartiality, right? I think that's an important part to it, and that's important in victim contact. For some people, the timing isn't right due to continuing pain, the trauma associated with the crime, the resulting anger. I mean, all of these things are very real in the cases that we come across. But we know that experience has shown us that many victims welcome a call from our program, even if they choose not to participate, because even saying no can be empowering. So to me, that contact, the way that contact is made, the information that is shared and how it's shared, it's an important piece to that victim-centered approach. I think the next piece is that it seems obvious, but their choice to participate, right? And that's not only about what information is shared, but as obvious as it seems, it's worth saying out loud. We would never continue a process without the offender and the victim choosing to participate. There are many programs out there that are offender-based, and they will go forward with the offender regardless of whether the victim is engaged. We are not one of them, and restorative justice is really based on that engagement of both sides, right? So I think, that invitation for involvement in and of itself can be a very positive offer for the victims. It shows them that they're important, that they're not invisible. In the criminal justice paradigm that we see, the court process usually offers victims nothing except the severity of the sentence as a symbol that it's taken their pain seriously, right? There is no other method to show that. And so the choice to engage or not has to be entirely theirs, and there can be no coercion or anything involved in that. I think that's really, really important to sort of what we do and how we do it. And then past that, it's the levels of participation. We've talked about that before, but those who do choose to participate, they do so in varying degrees, right? So based on their needs, based on their wants, some access only information, others want to collaborate on a reparation plan. Some want a voice, right? They may not want to hear back from the offender, but they want the offender to know how this has affected them. Some seek personal healing. They don't want input into the legal system. They want it to be separate. So we need to offer that. The victims need to be directing the process. And at the core of everything we do, that is what victim-centered is. They choose how much information is shared, the manner in which it's shared, whether or not they meet with the offender, what information goes back to the court in our process. When the process has met their needs, then it's time to close the case, right? So that level of participation and all of those things equal their satisfaction, right? I mean, it's fair to say that the more choice they have, the more control they have over the process, the more they're going to be satisfied. And I think that plays into my last point, and I promise I will let other people speak. But the most important, and again, this comes back to sort of our process, is that face-to-face meeting. Coming into sexual violence cases, there can be no expectation that we know what they need. It is the opposite of helpful. It is the opposite of what the movement has been doing to stop the cases coming to us to begin with, right? It's the opposite of helpful for us to come in and try to dictate what people want and what they need in order to move on from this. And so I think the same plays out whether or not they meet with their offender. They have to have control over that. They have to have choice in that. And there have to be other options if that is not what they want, right? If that's not what they want, what else can they get and how do they get it, right? So they need to have control over that. They need to have control over the means of communication. Placing people in a circle without significant and careful preparation, we've talked about this already, but it's risky. And if anything, it puts them at further risk of further victimization. And that's the last thing that we want to do through an RJ process is put them in more harm than they've already been through. So I think, all of the ways that we've talked about in preparing them for the circle or whatever the process looks like, we adjust accordingly based on their needs. And I think at the core of all that we do, that is what being victim-centered looks like.
Mm-hmm. Yeah, I think you've really definitely touched on tick all the victim-centered boxes there, just in your language, like, looking at control, choice, what's meaningful, victim-directed, victim-centered. Yeah, and not to cause any further harm, like continually reassessing that the preparation, the casework is done to not cause that further harm. But from a different perspective, I want to turn it to Mark. So what does Mark's a criminal lawyer. So what does being victim focused look like to you or in your practice, and how does it play out in the legal process?
Sure, and I'm a criminal defense lawyer, so I don't do prosecution work, I do defense work. I have a different perspective because I have to. I've taken an oath that I will do everything to defend my client to the best of my abilities, and I can't be victim focused. And it's unfortunate because sometimes, these are real people and real human beings in real life situations. But you have to keep in mind that that's not my role. Often at times, my role is to do what I can for my client. And we have to recognize the limitations too with our traditional criminal justice system on being victim focused. The Crown Attorney, for example, we consider them to be a small M minister of justice, meaning the Crown never wins or loses. They get what is right. And the Crown technically can't be victim focused, and nor can the judge be victim focused, because the judge has to balance a number of different principles, the rights of the accused to have a fair trial, the right of a victim to be heard, the right of a case to be judged on its merits. And a lot of times sort of the victim focus gets lost, and it gets lost because our system is set up so that it would be impossible for the defense, for example, to have a victim focused practice. That just simply doesn't happen. Now, having said that, I think we are seeing changes in the way the criminal justice system works. We are seeing certainly more respect for victims. Michael Edison famously in the late 1990s, I believe, made a comment about whacking a complainant at the preliminary hearing because that way they're not going to want to testify before a jury at trial. That type of thinking, I think, is really outdated. I think even from the defense perspective, there's a lot more respect for victims. There's a lot more respect for victims' rights. And we've certainly seen amendments in the criminal code with respect to disclosure, third-party records, with respect to the twin myths, with respect to past sexual history. I think, though, what is missing from our criminal justice system with respect to victims' rights is the restorative justice approach. That's completely ignored. And we're not going to have victims' rights or victim focus, process in the current criminal justice system the way it is, because it's structured so that it is impossible to do it.
Yeah, that's really, it's so neat to hear Amber's response next to yours, and where, people are coming at in terms of addressing sexual assault, sexualized violence. Very interesting. Maureen, you clearly in your work have a very victim focused practice. I wonder if you'd be able to speak to what it means to be victim focused.
So I think I align with much of what Amber said. We go into every situation as we believe you, that we are giving you choices, that you have all the control in this of what you want to do now or in the future. And so that is our bottom line. It's very non-judgmental. I heard a police officer say to me when the client was in the other room, and he said, well, this person is known to police. I said, yes, because victimized people are victimized, re-victimized many times. It's a vulnerable population. So we combat that, non-victim centered approach from some of our partners. And I think it's absolutely 100 times better than when I worked in Hamilton 25 years ago for the program. So things are changing, so I don't want to bash the police. But I think that putting all the control back into the victim's hands, helping them to understand that nothing they did or didn't do caused this to happen to them, that this was nothing that they had control of, because I still find almost 100% of clients will say, well, I shouldn't have been there, or I shouldn't have been drinking, or I shouldn't have, so we really need to, our job is to to validate that they, like Amber said, you treat them where they are, and this is just a fact. And you can choose to drink and drink too much, and this doesn't mean this is supposed to happen to you. So, you know, again, giving all the control back, that's where victim focused. We want to make sure they have the options and they have the control.
Thank you, Maureen. Yeah, I'm encouraged from both of you, Maureen and Mark, to see that over time we have made some progress in how we respond to victims and to these types of cases, and that we are changing, however, so slowly. Alan, did you want to contribute?
Yeah, thanks. Just a couple of things I wanted to add in. There are so many different expressions of victim-centered practice in restorative justice. It's really quite exciting to sort of take a look around the continent, at least, if not other continents, to see how various RJ programs practice victim-centered in a victim-centered way. In the United States, for example, one of the things you see very often is that only in cases like this, only victims can initiate, only survivors can initiate the process. That offenders aren't allowed to do that. There's a program, I think, in Delaware or Wisconsin, where if an offender wants to apologize, they don't get to sort of initiate anything. There's an apology bank. And they write their letter of apology, and that letter goes into a bank. And if a survivor is ever interested in looking to see if there's an apology, they can do that. For other people at Mary Koss, the Arizona Restore program, victims can veto the involvement of any other person in the room if they're not comfortable with somebody. For others, the victims always have to be the ones to say yes first. So many different ways of looking at it. I did want to come back to Amber. Amber, your explanation was so complete. I thought, oh my goodness, there's nothing I could possibly add, except I wanted to add one thing. And I'm reminded some of what you might call the leading edge, or what Howard Zare calls the healing edge of restorative justice work. Some of my colleagues out in Vancouver Island do continue to work with survivors, even if the offender declines. And I don't have experience of that myself, but there is an example that I did want to just toss out that might be meaningful here. There's a writer named Eve Ensler. She wrote a book called The Apology, and when she was growing up, she was massively mistreated by her father, like in every possible way. And it was just she started out her life so struggling just to have any sort of basic kind of sanity in her life. And so as an adult, she went through a lot of therapy, and she sort of came to really realize how the extent to which her father had victimized her. And she so wanted him to apologize to her. And he never did. And he died before he even seemed to have an impulse to apologize to her. And so from a therapeutic standpoint, you might say, well, okay, so that can never happen. But her therapist said, what if you were to write the letter of apology that you wish that your father could have written to you? And she wrote that, and she's published it, and it's an incredibly powerful example of some of the kinds of work on some abstract or theoretical level, maybe, and a very practical level, maybe, that we could do with survivors in the absence of offender interest or the offender being an appropriate person to participate in something like this, that can we hold out to add something more to our repertoire that assists survivors in their recovery, just by being more imaginative, right? And not tying what we do necessarily to the offender being willing to participate or not. Anyway, I just wanted to add that to the mix.
Mm-hmm. Yeah, I think one of the key things that I have found to be really helpful with restorative justice practice is sometimes we narrowly think about who the victim is. So we have the victim who's named in the charge, the complainant, they're listed, but sometimes there's these peripheral victims. So they might be the child of the person who did the wrong, or the parent of the person who did the wrong, or the child of the victim. So there's these additional impacts that never would get addressed, or never, those people would never be included in any process related to the criminal justice process. Um, these extraneous people who, will carry this with them for the rest of their lives and will have an impact in their relationships for the rest of their lives. And they never get the opportunity to have their say or to contribute to the process or get their questions answered. So a really neat thing that happens in restorative justice that we often don't recognize is, sometimes, for example, the parent of the accused is really struggling and is really harmed also by the act. And their, for lack of a better word, victimhood needs to be recognized and supports need to be put in place to help them through this process. So I think that's a big part of being victim focused. So who do I have on my list next? I have Sherry. Oh no, more. We had Maureen and Sherry. Yeah, about being victim focused.
Yeah, I think Amber really nailed it. Like she said, all the things that we would love to see and to see happen and have the right words at the right time in the right place. But unfortunately, we don't see that. And I'm just talking about some of the cases that we've seen lately, and they're come from the schools. So somebody reports a inappropriate touching or something happened at a party on Saturday night, and it gets through the school and the buzz, and the teachers hear it, and they have to report to the principal, and the principal has to call the police officers, and then police have to call children's aid. And it gets so blown out of proportion that it's like then a huge thing in the school. And it's like somebody just added gas on the fire, and there's different camps, and there's, people aren't talking, and there's like too many things going on where it could have just been like a simple, respectful conversation without it getting so vamped up and out of control. And a lot of times that really ruins a lot of people's lives and interferes with their family and their health. We've seen families move out of communities because they can't get anywhere with the school board, or their child isn't being believed, or they feel their child isn't respected. They're still making them be placed in the same room or the same classroom as the person who was the offender. So, I mean, and even in the court systems, like Mark is totally right. Like there's a winner and a loser. Like it does not have to be like that. Like we need to do better. We need to be kinder.
Mark, go ahead.
Yeah, I just want to pick up on a comment that Maureen made, which was when she gave an example and the police said, well, this person is known to us. And you don't get to pick your victim. And as Maureen said, a lot of people who deal with trauma end up in conflict with the law. And I think that's very important to recognize that and to embrace your, whoever the victim is needs services, even if they have themselves done bad things in their life, even if, they come before the community, they come before the courts or to the police attention, they need to be heard irregardless of their past.
Okay, I'm going to that question. Are there any additional professional development, training, tools, practices you feel are needed to deliver restorative justice as a response to sexual violence and sexual assault? So particularly to sexual violence, sexual assault. Are there additional, and I'm going to put it to Maureen.
Yes, I think, I don't know that much about the restorative justice programs in our community. So I've learned a lot during this preparation for this panel. And I understand that everybody has trauma-informed care training to do this work. I think for when you look at sexualized violence, there's the added information on gender-based violence, of the power and control variables that happen within this type of sexualized violence. Understanding that I think that the partnerships would need to be very close. So if we were working with sexual assault survivors, that the restorative justice group, it would be very important to have us all communicating, understanding the same things, going back and forth, so that we're giving the same information to our clients as they are, so we can give them those informed choices. So I think that's really important. I think, as well as, Interval House that does work with sexual assault as well. So any group in our community that is doing that work, the sexual assault crisis lines, important to do that, right? So that everybody's coming from the same place and offering what we can, and giving them that information. I think that's it.
Mm-hmm. Yeah. Good answer. Alan.
Yeah, thanks. Yeah, not much to add to what Maureen was saying. I think I would hold out, though. I don't think that being trauma-informed is the strong suit in the field of restorative justice right now. As I run around the country, which I'm very lucky to be able to do and deliver training or workshops here and there, talking with people about, so when you say it's important to be trauma-informed, what do you mean? And I remember talking with somebody in Halifax a few years ago who said, well, really, it just means being nice to everybody, right? And it was hard to not hold my head in my hands and just sort of weep, because it was so not what we're talking about. And so, I think we need to have a much more active and robust commitment to being trauma-informed in restorative justice than we currently do. And so certainly with respect to sexualized violence cases, there is trauma, but there's also sexual trauma, and associated with that is betrayal trauma, institutional trauma, all of these kinds of additional factors. And often when adults are victimized sexually, they were also victimized sexually as kids. And so you start to have to work with complex trauma, right? And so there's a lot of additional considerations in addition to simply the generic trauma-informed kind of things here. And I think another piece I just want to hit on is not so much additional training, but what we're looking for when we do train people in restorative justice. There's a researcher did some research in Australia a few years ago about this serious crime restorative justice program that worked incredibly well. Like the outcomes were just really amazing. Such positive feedback from victims and survivors and offenders and so on. And so the question comes up, and it's asked in the research, so what made this work? And a huge number of the things that made it work for victims were the attributes, the personality attributes of the facilitator, of the practitioner. And we sometimes give short shrift to that in RJ training. I really want to highlight that, because it's not just my own experience, but it's actual research experience that says, who we are as practitioners, who we are as RJ facilitators matters. It doesn't just matter a bit, but it matters enormously. And we need to be holding out for the right fit on a personal characteristics level, in addition to being able to hold out for enhanced levels of trauma informed practice.
Thank you, Alan. Yeah, I think it often doing this type of work attracts a certain type of person, and is influenced on who we are. I think that often the facilitators are the ones that we see stick with it. It comes from a place of who they are in the world and how they want to be and how they want to connect with others. Aisha Tour, our board chair, really explains that really well. Hi, Aisha. Being trauma informed, yes, all our facilitators take trauma informed training, but I think they're, that's ongoing. It's something that we can continue to learn about, continue to grow in. So in terms of our volunteers and facilitators, we're continually trying to offer opportunities for further education, for further understanding, for further connection with being trauma informed in terms of sexualized violence, or in terms of gender based violence, whatever we can do to continue to provide those opportunities. And then we have sort of a mentorship program. So you start off, after taking the training plus a few additional trainings, then you're an observer, and you do that until you're ready. And until we see that you're ready to move on to a facilitator position. Sometimes people just want to remain as an observer and never move on to a co-facilitator. And then they move on to a co-facilitator position where you can stay there and never be the lead. So it's an ongoing dialogue between Sherry and the facilitator to have a conversation about, how do you move through this process until you're ready. And we have like a mentorship program, really, where there's the lead facilitator who's been doing it often for 10 years or more, who mentor the newer facilitators coming in to ensure that the quality of the service provision and ensure that those connections can be made. Yeah, what additional professional development, training tools, practices do you feel are needed to deliver restorative justice as a response?
Yeah, and I agree with everything everybody said, like the continued education and everything. And I'm going to put in the chat, because this is the national symposium that's coming up next week. And there's all kinds of great workshops. Marley Lease is going to be there. And I'm going to put that in the chat. So I want you all, it's only $50 for the 2 days. I also want to just briefly touch on screening tools. So a number of agencies in the community members have, one of their biggest challenges for sending sexual violence cases to restorative practices is that there needs to be some kind of training or some kind of screening. And they believe that's like a mental health screening. But part of community justice and restorative practices, like, we're not therapists, and we're not there to do any kind of therapy, but we're there to maybe get those services and supports in place. So when somebody from the community says, well, how come you can take that case? Like, that person has mental health issues, and that person needs to go through mental health. Well, maybe they do have mental health issues, and maybe they've had them all their life, and maybe they've just got them. I don't know. And I don't really care, to tell you the truth. Like, you know what I mean? I'm just there to make sure they have a respectful conversation, and to make sure they have, I shouldn't say I don't care, and make sure they have the supports that they need in place. And that support person can come with them. They can have whoever they like there. And so for a screening tool, I don't know if you're talking about like screening from the Crown, screening from the police, who should screen what, but I think it needs to be consistent. So I think the Crown and the police, I think this is all new to people, and they're not really sure what is consistent and what is not. And I think we need to better educate police services and Crowns. There is a right for them to have diversion, it's the law.
So Marley, for people who don't know, Marley Less was our panel, and Kara Sweeney, a lawyer from Toronto. Marley Less is a young woman who was raped in Toronto, and that video can be found on our website if you want to go and look at that.
I just wanted to add two things that I think could be helpful when you're looking at setting up RJ practices and how to make sure that they are delivered sort of in the best way that you possibly can. So I think two things that I just wanted to add to the conversation is our program benefits from an advisory circle. And this is a group of community experts with diverse backgrounds. We have lawyers, victim service providers, Crown Defense and human rights lawyers, police officers, and also a psychologist. And so the benefit of having that advisory circle that meets on a monthly basis is that it allows us to take some of our difficult cases. Every single one of the sexual assault cases that has been referred to our program has been discussed at this advisory circle, because I feel that, as Sherry said, we are not counselors. We don't always know exactly what to do. And so we benefit from their diverse perspectives, right? They help us see different things. They give us different ways of looking at things. Do you know what I mean? Like it's just about looking at it from all different angles. And I think sometimes you might get stuck in one way of seeing it. And I just think this advisory circle brings that multitude of perspectives that I think is really helpful in doing this work. And so we've really benefited from that. And it's something I think that's really important for any RJ organization, is to have that outside help. I mean, you're not taking specifics, you're not taking names, it's all confidential, but absolutely that outside support from some of those professionals is really, really helpful. And then I just wanted to add that here in Ottawa, we, the Collaborative Justice Program has been really lucky in being part of exactly what you were talking about, Maureen, where it's this convergence of community groups, grassroots organizations, nonprofit agencies, community representatives that represent sort of the spectrum of RJ organizations and sexual assault victim providers. I mean, everything and anything in between. There's about 30 of us that have started to gather here on a semi-regular basis, that are really looking to make those connections that you were talking about, right? To sort of make sure that we all have the same information, that we know what exists, that, you know, if we're hearing things from our victims, we know what the reality is in the landscape that we exist in. So if there are referrals to be made, if there are connections that would be helpful, we're trying our best to be known to each other. And I think it's been a difficult conversation. It's been difficult to get that stuff going, but I think what you're saying is exactly important, is that you need those connections in order to make sure that all of the pieces are being taken into consideration, because an RJ process is not the only thing that's needed in response to sexual assault, right?
Yeah,
there are multiple layers of supports and we cannot possibly do it all. And so that ability to sort of lean on each other and use each other and refer to each other has been really, really helpful. The group continues to meet, we ebb and flow, you know, sometimes there's more at the table, sometimes there's less, sometimes people are busy, but I think the important thing is that the connections are there to be used to the best of our ability. So it's really about challenging each other and trying to find better ways of dealing with these things that we know are not being done well. So it's a starting of a conversation, but I think it's an important piece. And if people are able to do that more in their own communities, I think it can only strengthen how we do this work.
Absolutely, Amber. I totally agree. Like the ability to collaborate, like you don't know what you don't know. So you need to create relationships with other organizations, other people, other service providers, so that, you know, they're there to support you and you doing your work, but you're also there to support them in doing their work, so that the circle of care is a circle. It's not a broken circle. It's a complete circle where the person has the resources available to them. So I think that's really exciting. I'd like to end on a really good note. So what does reparation look like? And when is it more effective? So we're jumping to the last question, my panelists. I'm throwing it out there. Amber.
I think it's different for every case and every person in every situation. But I think it's possible, right? I think we know that what's most important is honest, sincere communication between the parties. And that's the stepping stone that you build other pieces on. If that isn't there, I think the other stuff falls away. But we know it includes answering questions in a fulsome, honest way. It means apologizing from the heart. In whatever form that takes. It's active listening and acknowledgement of the impacts of the harm done. And then from there, it can take whatever direction the parties want it to take. It can be help with counseling, it can be courses, it can be education, it can be prevention measures, symbolic gestures, volunteer work, donations to charities. I mean, the restorative process is as creative as the parties want it to be, and yet the reparation piece is built on the foundation of acknowledgement of harm and open and honest communication between the parties.
Thank you, Amber. Comprehensive answer once again. Alan.
Always hard to follow Amber.
It is hard to follow Amber.
In these conversations. Remind me next time we do this. I'd like a different
You
order.
want to go first?
Yeah. Just to add a couple of things to that excellent answer. I think we need to make sure that reparations are tied to victim needs. That it's not a, here is my cat, and I'm giving you my cat as the offender, and that's not what the survivor wants, right? And so there needs to be a really clear connection between victim needs and reparation. Philosopher Margaret Urban Walker talks about truth-telling as an act of reparation, and maybe that's a little bit on a more somewhat symbolic basis, or less material anyways. But still, it's the idea that reparations are contextual. They need to matter to the people involved. They might mean nothing to anybody outside those two. That's okay. And that, of course, whatever is offered is voluntary, right? There's I'm not sure what it's like in Ontario, but here in Alberta, there's far more than enough self-described restorative justice work going on, where things like apologies and acts of reparation are imposed on the offender and with no victim input whatsoever. Some version of what you might call garbage practice, but it's whatever it is or is not, it's certainly not good restorative justice practice. So yeah, that it be given voluntarily from the heart, as Amber was saying, I think is key as well. So thanks.
Mm-hmm. Thank you, Alan. Mark.
Well, when I think you come from a criminal defense lawyer background, you're normally looking for the least restrictive reparations, but that's not what restorative justice is about. And I think everybody's is hit it. It has to be voluntary, and it has to be from the heart. And I think realistically, we have to look at, what do we want to establish from the process? Do we want to hurt, or do we want to heal?
Thanks, Mark. Maureen.
I don't really have anything further to add. I think everything Amber has said, it should be whatever the parties get out of that is what their end goal is.
Awesome. Sherry, do you have anything you want to add?
I just want to add that this is the place where I've seen genuine remorse, and where the victim or the complainant has, and you won't see that in the court. No.
Yeah, so when I think of reparation, I don't so much about truth and reconciliation in the media today, that it's hard to get to reparation without accountability, right? We hear that, and we use the term restorative justice, and sometimes I think I'd love to have that changed to transformative justice, because we don't want the relationship that we had in the beginning. We want a transformed relationship, and that often can happen with accountability and restoration, right? We want something transformed, something different than how it started or how it is, when everything is going through the criminal justice process. So transforming those relationships is so critical to the restorative justice process, and repairing those relationships. So I'm just going to share those results with you. So it looks like 98% increase their understanding of the opportunities for a restorative justice response to sexualized violence, sexual assault. 95% felt that the discussion adequately highlighted some of the advantages of restorative justice response to sexual assault. 95% that I highlighted some of the challenges. That's good. And oh yeah, more than what I thought would be an increase in I agree with restorative justice response to sexualized violence, sexual assault. That's actually a lot higher than I thought it would be. Because of our limited time. So that's exciting to know. But I really, really appreciate everybody coming. I thank you so much. Hopefully we can do something like this again in the future. There's a lot of questions. We still have questions. We still have things that we want to examine and prepare and plan and respond to and dealing with these types of cases. And we hope that you continue to engage with us and explore our understanding in the years to come. And we'll continue to engage the greater community in that process. And I love Amber's idea of, like a committee that you can go to discuss these more complicated cases, especially for sexual assault, sexualized violence. And feel free to reach out to our panel members. Then remember their contact information is in the chat. If you somehow didn't get it, you can just scroll up or just contact us and we'll forward that to you. And lastly, I just want to let those of you who are on know that Lanark County Community Justice has to fundraise $30,000 to $40,000 annually, and I might get my hands wrapped by the fundraising committee if I didn't let you know that. This is a free event, but you can easily go to our website, click donate, and make a donation to our program, or you can join me and my family at the Perth Polar Bear Plunge, which is happening in Perth on New Year's Day. We're going to jump into the Tay River at 10 o'clock in the morning. There's lots of information about that on the website. If you want to pledge me and my family to jump, you can do that too. Or just please consider making a donation to Lanark County Community Justice. Again, $30,000 to $40,000 annually is a lot to worry about every year, so your help is appreciated. Again, thank you everyone for coming today. Thank you for your valuable time. I hope you're not zoomed out, and I'm glad you came, and thank you. Everybody else say goodbye.
Great. Bye.
Bye.
Bye, everyone.
Thanks, everybody.
Bye.
Take care.
Thank you so much,
Great
everybody, for your
team.
participation.